Welcome to the Law in Context podcast, Season 2.
We're the two Steves. I'm Emeritus Professor Stephen Bottomley.
And I'm Emeritus Professor Stephen Parker.
We have both been deans of major law schools, and we collaborated on the first two editions of a book called Law in Context.
These podcasts explain fundamental legal concepts in an accessible way.
Whether you are a member of the public wanting to know more about law and make sense of what is in the news,
Or you're thinking of studying law,
or you are already a lawyer looking for a refresher course,
this podcast is for you, with transcripts and more about us, two Steves, on our website at lawincontext.com.au.
no criminal justice system is perfect. Sometimes it miscarries.
It's impossible to know whether miscarriages of justice are happening more or less frequently than in the past. Perhaps there's more media investigation of cases today, bringing them to light. And of course, there are now true crime podcasts which go into old cases. In this episode, we look at a few examples and we search for common themes.
We also look at recent scandals where governments themselves have inflicted miscarriages of justice on a large group of people, what we might call mass miscarriages of justice.
The starting point, of course, is that in a criminal trial, the onus is on the prosecution to prove their case beyond a reasonable doubt. But sometimes something goes wrong at the prosecution end, for example, police corruption. Sometimes the prosecution does not disclose all the evidence to the defendant as it should do.
Sometimes the 12 members of the jury are biased. Sometimes a judge points them in the wrong direction. And occasionally the defendant has pleaded guilty, so there is no trial at all. Maybe they've been told they will certainly be convicted and it's better to take a lighter sentence for pleading guilty.
In episode 5, we heard of an even more bizarre scandal where an Australian defence barrister, Nicola Gobbo, colluded with the police to betray her clients and seemingly frame completely innocent people.
Let's start with a few notable examples from around the common law world. In the United States, one such case was the Central Park Five in 1989. 5 teenagers, aged between 14 and 16, were wrongfully convicted of assaulting and raping a jogger in New York City's Central Park. Their convictions were based on coerced confessions obtained after prolonged police interrogations without legal representation and weak forensic evidence. They were sentenced to between 5 and 15 years imprisonment. In 2002, after the real perpetrator confessed and DNA evidence confirmed his involvement, their convictions were overturned.
An older case was the Scottsboro Boys in 1931. 9 African-American teenagers were falsely accused of raping 2 white women on a train in Alabama. They were tried within a month of their arrest and had to be protected from a lynch mob. Despite weak evidence and contradictory prosecution evidence, they were convicted by all-white juries. Over the years, their cases underwent multiple retrials and appeals, highlighting deep-seated racial biases in the legal system. By 1950, all had been released or escaped, and in 2013, they were posthumously pardoned.
In the United Kingdom was the 1974 case of the Birmingham Six. 6 Irish men were wrongfully convicted for pub bombings in Birmingham that killed 21 people. Their convictions were based on coerced confessions obtained under police brutality and flawed forensic evidence. After serving 16 years, their convictions were quashed in 1991 following a prolonged campaign for justice.
Very recently is the case of Andrew Malkinson. In 2003, Malkinson was wrongfully convicted of a rape he did not commit, leading to a 17-year imprisonment. Despite maintaining his innocence, his appeals were repeatedly denied. Crucial DNA evidence, which could have exonerated him, was overlooked for years. It wasn't until 2023 that his conviction was quashed after this evidence came to light. To make things worse, England has a Criminal Cases Review Commission to investigate potential miscarriages of justice. It received multiple applications from Malkinson seeking a review of his conviction. However, the Commission failed to act promptly and thoroughly. An independent review in July 2024 highlighted these failures, stating that the Commission's inaction contributed significantly to Malkinson's prolonged wrongful imprisonment.
You're listening to the Law in Context podcast by the two Steves.
Remember to rate us on the platform you are using.
Now, back to one of us.
And the UK may or may not be in the middle of another such case, although we stress that at this stage the conviction stands and we have no personal views on the matter. In August 2023, Lucy Letby, a neonatal nurse at the Countess of Chester Hospital in England, was convicted of murdering 7 infants and attempting to murder 7 others between 2015 and 2016. The prosecution's case heavily relied on expert medical testimony, particularly from a doctor who suggested that Letby had harmed the babies through methods such as injecting air into their bloodstreams, causing air embolisms. Letby appealed, unsuccessfully, to the English Court of Appeal on 2 occasions. Now, doubt has been cast on the reliability of this expert evidence. Just this year, an international panel of 14 medical experts, led by a retired Canadian neonatologist, reviewed the medical evidence presented at Letby's trial. The panel concluded that there was no medical evidence to support the claim that Letby deliberately harmed the infants. Instead, they attributed the deaths and injuries to natural causes or substandard medical care, highlighting issues such as inadequate staffing and delays in treatment at the hospital. Letby's legal team has now submitted an application to the Criminal Cases Review Commission, arguing that the new medical evidence undermines the safety of her convictions.
In Australia was the world-renowned case of Lindy Chamberlain in 1980. She was wrongly convicted of murdering her 9-week-old daughter, Azaria, who disappeared from a campsite near Uluru. Chamberlain maintained that a dingo took her baby, but she was convicted based on circumstantial evidence and possibly public prejudice. In 1986, Azaria's jacket was found near a dingo lair, supporting Lindy's case. A royal commission ultimately led to the exoneration of Lindy and her husband Michael in 1988.
And in 1994, Andrew Mallard was wrongfully convicted of murdering a Perth jeweller. His conviction was based on a coerced confession and withheld evidence. After serving 12 years in prison, the conviction was quashed when it was revealed that crucial evidence had been suppressed and investigative misconduct had occurred.
Although these and other examples we could give are only a tiny percentage of cases in criminal justice systems, they are alarming and reduce public confidence in the police, courts, and the law as a whole. Scholarly research into miscarriages of justice has identified several recurring themes that contribute to wrongful convictions across various legal systems.
Eyewitness testimony has been shown to be highly fallible. Misidentifications occur due to factors like stress, poor lighting, and the influence of suggestive identification procedures.
Astonishingly, individuals sometimes confess to crimes they did not commit. This can result from coercive interrogation techniques, psychological pressure, or the individual's mental state.
Faulty forensic analysis, including contamination of evidence and misinterpretation of data, have clearly led to wrongful convictions.
Deliberate false testimony from witnesses, whether motivated by personal gain, coercion, or bias, can mislead juries and judges. Misconduct by law enforcement officials, such as withholding exculpatory evidence, tampering with evidence, or coercing witnesses, has been documented as a significant contributor to a number of wrongful convictions.
Defendants who receive poor legal representation, whether due to under-resourced public defenders or inexperienced lawyers, are at a heightened risk of wrongful conviction. They may, for example, fail to challenge weak evidence or to present a robust defence case.
Then there is so-called confirmation bias. Investigators and prosecutors may develop a theory of a case early on and subsequently interpret evidence in a manner that confirms their initial beliefs, disregarding contradictory evidence.
Finally, there is the problem of insufficiently advanced scientific evidence. In 2023, Australian woman Kathleen Folbig, who had spent 20 years in jail following conviction for the murders of her 4 infant children between 1989 and 1999, had her convictions overturned when new scientific evidence revealed that children had rare genetic mutations that could cause sudden death.
Running throughout these themes is the prevalence of prejudices against defendants because of their ethnicity, lifestyle, or attitude in court, prejudices which the criminal justice system fails to pick up or itself has exhibited.
There is no way of knowing whether adversarial legal systems lead to more injustices than inquisitorial ones. The defenders of the adversarial system vehemently argue that it is better at protecting defendants. On the other hand, the judge in an adversarial system has a largely passive role. No doubt if the judge sees something going wrong, they may intervene somehow, but that really isn't their role. In an inquisitorial system, it is the judge or panel of judges who lead the direction of the case.
Then there are instances of mass miscarriages of justice by governments. Here the victims might not even go to court. They could lose their social security or rather entitlements, or they might be amongst such a large group of defendants that the system begins to accept that a crime must have been committed.
The Australian Robodebt scandal exemplifies the first of these. Between 2015 and 2019, the Australian government used an automated system of income averaging to determine that some people were not entitled to social security or must repay what the system said had been overpayments. According to the Royal Commission appointed to investigate the affair, this caused stigma, shame, financial hardship, and great suffering, possibly leading in some cases to suicides and family breakdown. The government ignored findings from its own Administrative Appeals Tribunal that the scheme was unlawful.
In the UK post office scandal, which is still unfolding, a software system called Horizon was implemented in the late 1990s, which incorrectly showed that money was missing from a large number of post offices. Hundreds of post office managers were prosecuted, some went to prison, some committed suicide, some had heart attacks, and all suffered. Incredibly, for an affair that was known about for several years, it was not until an ITV television series in January 2024, Mr. Bates versus the Post Office, that the public really took notice. The series received critical acclaim for its portrayal of what has been called one of the greatest miscarriages of justice in British legal history.
So, is there any reason to be optimistic in the light of these examples, which are only a minority of the documented miscarriages of justice? The legal profession is not blind to the problem. Around the world, groups of lawyers and law students, often working pro bono, have created very effective lobby groups and innocence projects to investigate and advocate for victims of wrongful conviction.
Improvements in DNA technology perhaps give some cause for optimism, potentially proving innocence, or at least reliably pointing to guilt.
Perhaps the development of artificial intelligence will allow masses of evidence to be analysed more dispassionately and accurately. Perhaps not. At this stage, technology arguably drove the miscarriage of justice in the Robodebt scandal, coupled with an unwillingness of public servants to oppose the wishes of government. And blind faith in IT is a major factor in the UK post office scandal, coupled with management cover-up and unprofessional lawyers.
Perhaps more scrutiny of expert evidence is appropriate and on the way. There are statistical techniques now that pick up flawed research and outright research misconduct. This means there are new ways of discrediting the basis of some expert evidence.
Perhaps repeated discussion of miscarriages of justice will keep reminding us that they do happen and makes us vigilant.
At the end of the day, the requirement to prove a case beyond reasonable doubt requires scepticism about everything by everybody. I thought that was a good episode.
I doubt it.
Why?
You just said we should be sceptical about everything.
Thanks for listening to this episode, brought to you by The Two Steves. You can find more in this gripping series at lawincontext.com.au or wherever you get your podcasts.
Send us a question or add a comment on the website.
And as Sergeant Esterhouse used to say in Hill Street Blues,
let's be careful out there.
Bye.
Bye.